Pennsylvania's lease termination laws are shaped by the same dual framework we discussed in our habitability video. State law provides the foundation, but local ordinances in cities like Philadelphia can add significant additional requirements. If you manage rental property in Pennsylvania, knowing which rules apply to your specific location is essential. Pennsylvania's landlord-tenant law is found primarily in the Landlord and Tenant Act of 1951, Title 68 of the Pennsylvania Consolidated Statutes, Chapter 2, along with various provisions scattered throughout the state code. The state also has a specific eviction procedure under the Landlord and Tenant Act that governs how possession is recovered. Let's start with no-cause termination. For month-to-month tenancies, Pennsylvania requires the landlord to provide at least 15 days written notice if the property is located outside of Philadelphia. That's right, 15 days, not 30. This is one of the shorter no-cause notice periods in the country and gives Pennsylvania landlords outside of Philadelphia significant flexibility. However, and this is critical, if the property is in Philadelphia, the rules are completely different. Philadelphia's good cause eviction ordinance requires landlords to have a legally recognized reason to terminate a tenancy. In Philadelphia, you cannot simply give a 15-day no-cause notice and ask the tenant to leave. You must have good cause, which includes non-payment, lease violations, the landlord's intent to occupy the unit, or other specific grounds listed in the ordinance. This makes Philadelphia one of the most restrictive cities in the country for lease termination. For year-to-year leases outside of Philadelphia, the landlord must provide notice at least 30 days before the end of the lease term if they don't intend to renew. If proper notice isn't given, the lease may automatically renew for another term. For fixed-term leases of less than 1 year, the lease expires at the end of the agreed term without additional notice required, unless the lease specifies otherwise. If the tenant stays beyond the term and the landlord accepts rent, the tenancy converts to a periodic tenancy. For week-to-week tenancies, the notice period is the length of one rental period, so 7 days. Now let's cover termination for cause. For non-payment of rent, Pennsylvania requires the landlord to provide a 10-day notice to quit before filing for eviction. This 10-day notice informs the tenant that they must either pay the rent owed or vacate within 10 days. If the tenant pays the full amount within the 10-day window, the notice is satisfied. If they don't, the landlord can proceed with filing a complaint in Magisterial District Court. Here's an important detail about Pennsylvania's non-payment process. For the first year of a lease, the notice period is actually longer. If the tenant has occupied the property for less than 1 year, the landlord must provide a 10-day notice. But if the tenant has been there for 1 year or more, the required notice is 30 days. This distinction catches many landlords off guard, so make sure you know how long the tenant has been in the unit before issuing your notice. For lease violations other than non-payment, Pennsylvania uses a similar framework. The landlord must provide a notice to quit, either 15 days for tenants who have been in the unit less than 1 year, or 30 days for tenants who have been there longer. The notice must identify the violation and inform the tenant that they must cure the breach or vacate within the specified period. Pennsylvania does not have a statutory provision allowing termination without an opportunity to cure for repeated violations, at least not at the state level. This means that technically, a tenant can commit the same violation, cure it during the notice period, and then repeat it, and the landlord has to go through the notice process again. This can be frustrating, but it's the current state of the law outside of jurisdictions with local ordinances that address this issue. For criminal activity, Pennsylvania allows landlords to pursue eviction when a tenant engages in illegal activity on the premises. The Strike 3 provision under the Controlled Substance, Drug, Device, and Cosmetic Act allows landlords to seek eviction when a tenant has been convicted of drug-related offenses on the property. Additionally, the landlord can file for eviction based on any activity that constitutes a threat to the health, safety, or welfare of other tenants or neighbors. Philadelphia adds extensive additional requirements for termination. Beyond the good cause requirement, the Philadelphia landlord-tenant laws require landlords to go through specific procedures, including providing tenants with information about their rights, offering opportunities for mediation in some cases, and following detailed notice and documentation requirements. Philadelphia also has a mandatory pre-filing diversion program for certain eviction cases, requiring landlords to participate in a mediation or assistance process before they can file in court. Pittsburgh has also been expanding its tenant protections in recent years. While not as extensive as Philadelphia, Pittsburgh has enacted ordinances addressing specific aspects of lease termination and tenant rights that go beyond state law. On the tenant side, Pennsylvania provides several grounds for early termination. Tenants can terminate if the landlord fails to maintain the property in habitable condition. As we discussed in our Pennsylvania habitability video, the tenant must provide notice of the defect and allow the landlord a reasonable time to make the repair. If the landlord doesn't act, the tenant can pursue remedies, including lease termination. Active duty military members are protected by the Federal Service Members Civil Relief Act and can terminate with 30 days' notice following deployment or permanent change of station orders. Pennsylvania does not have a comprehensive state statute providing early termination rights specifically for victims of domestic violence, though some local ordinances, including in Philadelphia, do provide these protections. Tenants who are victims of domestic violence and need to terminate early should consult with a local attorney or domestic violence advocacy organization about what options are available in their specific jurisdiction. Pennsylvania strictly prohibits self-help evictions. Landlords cannot change locks, shut off utilities, remove doors or windows, or take any action to physically remove a tenant without going through the court system. Under the Utility Service Tenants' Rights Act, shutting off utilities to force a tenant out is specifically prohibited and can result in penalties. The tenant can recover damages, and in some cases, the court can award additional penalties. The eviction process in Pennsylvania starts in the Magisterial District Court. The landlord files a complaint, and the court schedules a hearing, typically within 7 to 15 days. If the court rules in the landlord's favor, the tenant has 10 days to appeal to the Court of Common Pleas. If no appeal is filed, the landlord can request an order for possession, and the constable carries out the eviction. If the tenant appeals, the case moves to the Court of Common Pleas for a new hearing. During the appeal, the tenant may be required to pay rent into an escrow account to remain in possession. The appeals process can add several weeks or even months to the timeline, so landlords should plan accordingly. One important consideration: Pennsylvania recently passed Act 33 of 2024, which made updates to the Landlord and Tenant Act regarding the eviction process and timelines. Landlords should make sure they're operating under the current version of the law, as procedures may have changed from what was in effect previously. Pennsylvania requires landlords to return the security deposit within 30 days of the tenant vacating the property. The landlord must provide a written list of any damages and the cost of repairs. If the landlord fails to comply within 30 days, they forfeit the right to retain any portion of the deposit and may be liable for double the amount of the deposit. For the complete guide to Pennsylvania lease termination laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our series.